ladies and gentlemen, is designed to bring it down from the 30,000 foot level down to ground level. These individuals that are on this panel are active practicing attorneys that practice locally here in the state of Georgia, and more particularly in this Clayton County region. We have on this panel first Mr. Aegis Bray III. Aegis is a staff attorney at the Public Defender's Office here in Clayton County. He has been representing criminal defendants in the Clayton County Superior Courts for the last 5 years. Prior to that, he spent 5 years in the Public Defender's Office in Dougherty County, which includes the town of Albany in southwest Georgia. His practice has been geared towards criminal defense. He has represented clients charged with all types of criminal offenses, from most misdemeanors all the way to serious violent felonies, such as homicides and robberies. His appellate work includes appeals before the Georgia Court of Appeals and the Georgia Supreme Court. He is a graduate of the University of Southern California Law School, and he has a bachelor's degree of arts from Morehouse College here in Atlanta. In addition to Georgia, he is also licensed in his home state of Illinois. Please welcome Aegis Bray. Stephen Fryer is an attorney who practices primarily here in Clayton County. He practices almost exclusively criminal law. He is a second-generation lawyer who worked initially for his father, William E. Pete Fryer, a trial lawyer as well. Stephen has obtained defense acquittals in both federal and state courts. He has also had cases reversed in the 11th Circuit, the Georgia Supreme Court, and the Georgia Court of Appeals. Stephen graduated as a UGA undergrad and an Atlanta Law School law graduate. Stephen has been also active in working on campaign committees to elect and re-elect judges in Clayton County since the early 1990s. Most recently, he worked on a team of lawyers who secured an acquittal for the local Clayton County Sheriff, Victor Hill. Please welcome Mr. Fryer. The next lawyer is Ms. Kristen L. Hall. Kristen is the principal in the law offices of Kristen L. Hall. Her practice is a broad-based litigation practice focused on personal injury matters of both plaintiff and defendants. Kristen served as counsel for insurers for 14 years and knows the inner workings of insurance claims departments. Kristen also serves as a trial consultant to other firms in substantial and complex matters such as trucking cases. Litigating for over 20 years, Kristen has handled litigated cases in many of Georgia's 159 counties across the state. Her additional experience includes, but is not limited to, criminal defense, medical malpractice, nursing home litigation, and catastrophic accidents. A significant portion of her practice involves pro bono matters. Kristen has also been involved in continuing legal education, symposiums and programs in Georgia on varying topics involving trial skills and strategies. She has also served on the Fulton County Juvenile Court Judicial Nominating Committee. Kristen is active in local bar associations and serves on committees producing programs and continuing legal education programs. She is also a member of the Georgia Black Women's Attorneys Foundation and GAPWA. Please welcome Ms. Hall. Robert Kenner Jr. is a 1990 graduate of Savannah State College. After graduating from Savannah State College, Robert went on to receive a master's degree from Penn State University. He then received his law degree from John Marshall Law School. Robert practices in the area of criminal defense and personal injury. Robert has handled several high-profile criminal cases and has successfully argued cases before the Georgia Court of Appeals and the Georgia Supreme Court, and he has been a tireless defender of his clients' rights. He has not lost a case in the last 8 years. Please welcome Robert Kemp. Okay, as I said, these lawyers are on the front lines of everyday legal practice, representing clients before the trial courts in this state. They have firsthand knowledge of what it takes to be a trial lawyer. They experience the vicissitudes of the various judges that they appear before on a daily basis. So what this panel has to offer us here is, from a firsthand, face-to-face basis, what it means to practice in this state for the judges that currently occupy the state bench. So the first question I want to pose to this panel is, what are the most important qualifications for a trial judge? And I'm going to throw that out to Aegis first.
Now, this is probably the first and only time for anyone that's practiced with me that I've ever actually had to use the microphone. But my belief is that the most important thing a judge needs to do is their knowledge of the law. I think that takes precedence even over experience, even over temperament, things like that. And the reason I think so is because in a lot of ways, your judges are your gatekeepers to everything else. When someone gets arrested, the magistrate judges that sign those warrants, the magistrate judges that generally sign the search warrants that lead to evidence, those are the gatekeepers. They keep a lot of what we would consider to be garbage cases out of our system. They keep a lot of people from getting arrested for things they maybe shouldn't have. They keep a lot of search warrants or a lot of searches out before we even get started. And then once you get into the system, of having a judge that has knowledge and has a familiarity with the areas that we're talking about, it helps, because it helps tell us which way, not only which way is the case going to go or which way that we should expect it to go, but also it lets us know that they have reviewed and they've studied our case, they understand our positions, whether they agree or disagree with them. And it's a lot easier for not only us to be able to prepare our defense and our strategies, but it also gives our clients the feeling and the understanding that the judge actually cares about their circumstance. If a client is complaining that a search warrant is a problem or they're raising an issue, when the judge has reviewed the evidence and when the judge knows the case law, it tells that client that this judge is aware of what you're raising. They're aware of that issue, and they've taken the time out of their day to look into it and make sure that what has happened to you has been within the bounds of the law. And when it hasn't, that they're able to take those steps to alleviate the problems right away. So it helps both for ourselves and for our clients. And as any defense attorney will tell you, anything that makes the clients happy makes us happy, without question. So that would be my take on that. Steve?
Steve, same question.
Quite the opposite. I think that temperament is 99% of it. I was talking with Ms. Hall prior, and we were just sharing stories, and a knowledge of the law is, that really is that'll get there. I mean, you know, whether or not they're learned hand at the moment they step in the door is not the most necessary thing. I think a judge is at its best when they're 90% human and 10% lawyer. And, you know, I've seen 1,001 judges take their knowledge of the law to shut me up and not let me even finish my argument. A lot of times my argument might not rise to the level of protecting you entirely or protecting my client entirely from your power, but it could color what you decide to do at the end. You know, a lot of times having a judge look at you with their arms crossed and you're 10%, 20% into what you're about to tell them, and they interrupt you to make you commit to something. Well, isn't this all about X, Y, Z? Because if you say yes, then they've got an answer that shuts you up and sits you right back So, I once saw an attorney general tell a judge, well, Your Honor, you can't do that. Your Honor, you can't do that. You can't do that, to everything that the defendant suggested, because there was plenty of room and reason why to do it. And finally, he looked at him and he said, well, why don't we go out in the courtroom and just figure out what I can do? And then he went out there and was willing to try to help. There's nothing like getting a good healthy dose of the judge's knowledge of the law when it's always used to shut you up and sit you down. So that's how I feel about that. To me, experience as a trial lawyer, that usually translates into, hey man, I've been there where you are, so I know you're disappointed, but sorry. To me, it's all about temperament, because, at the end of the day, we're asking human beings to run this system, and so we've got to make room for the human being factor to be its best and it reflect in our community and at the courthouse.
Kristen, let me ask you that same question.
And I'll just speak very briefly. In the conversation before the program began, I was reminded of probably a few instances where I had to educate a fresh judge. So many prosecutors are appointed or elected to the bench now that they may not be as familiar with the civil law and civil procedure. And I have actually been thanked and commended in private by judges who appreciated my education during the course of the trial, that I blended into the theme of the case so that they would not feel embarrassed about having to reserve ruling or having to step away from the bench. All of that to say temperament is so important. You appreciate a judge who knows the law and respects the law and will follow it, because that's what we live and die by. But the temperament of your judge is so critical. It makes all the difference.
I want to come back to temperament in a second, but I want to give Robert the opportunity to weigh in on that same question.
Well, I concur wholeheartedly with Steve regarding.
Can you pull the mic a little closer, please?
I'm sorry. I concur wholeheartedly with Steve in terms of the importance of a trial judge, and I think it is temperament. So often we come before judges who they may understand the law, but they just don't care about the law. And what they do is they try to rationalize or they try to reason in such a way that basically it just undercuts the law just because they want to get to what they want to get to. So I've come before judges who they're very rude, disrespectful to not only the defendant as well as to the attorney. They have no compassion at all. Counsel talked about the fact that you have a lot of prosecutors who are ascending to the bench. And I think that one of the problems that I see, and there are a lot of prosecutors that I know very well, and they're decent people, and I think they do have the right temperament. But one of the things that I do see is that they kind of, once they put that black robe on, they lose their mind. And, they're human, but it's something about that robe that makes them think that they're God, and that they can, decide whatever they want to decide regardless of how you feel. And what they do forget is that you are making a decision that's going to affect somebody's life, somebody's brother's life, somebody's mother's life. And so when you get on the bench and you say, well, I'm hard on crime, but that's fine. You can be hard on crime and you can apply the law in such a way that you want to administer, certain type of sentences, but you have to have the compassion and the understanding and the temperament to know that, this was his first offense. And perhaps he was not the person who was directly involved, but he just got caught up. You have to understand that, people do make mistakes. And so when you take the attitude that, well, I'm hard on crime and I'm going to administer the law in a way that, I don't want to ever see this person come back, what you're forgetting is that's a voter. And that person's mother or father, they're gonna be voting the next time that your name is on the ballot. So I think temperament is the key.
Well, let me ask you, several of you mentioned the word temperament. How do you define temperament? What is the temperament? People out here in the audience may not know what lawyers mean when they say a judge has to have a certain type of temperament. Anybody?
I think that, I think to some degree, the temperament should be, and this is more criminal law, is to have some degree of respect for an agreement that both parties reach. Let the lawyers be lawyers, do their job, now, obviously, if there's if one end of this is not doing their job, then that'll flesh itself out and we'll correct it. But not to always be so critical of what's happening. And, it does, everything, if the answer is no, it doesn't have to be hell no. I might not be right, but I don't necessarily need ass kicked, And I think that's what, to me, that's the temperament you're looking for.
For me, it's a fundamental respect for the litigants and defendants, not just because our system says defendants are innocent until proven guilty, but that when you are sitting on that bench, you are in such a position of power. Patience is necessary. So many judges will cut a case short because they know exactly where it's going. And if you've practiced in Atlanta metro area, maybe you've run across some of this a little bit, where you are not allowed to fully represent your client, tell their story, and present your case. That's a basic disrespect. And so a judicial temperament means a fundamental respect for the litigants and defendants in criminal cases. In my mind, it also requires a bit of compassion and appreciation for the community that this person comes from in judging their case, be it civil or criminal. And you have to be decisive as a judge, but as he says, reaming people in the courtroom is not a part of an appropriate judicial temperament. My thoughts.
Okay, let me lead into another question. You guys mentioned just now that many judges are ascending to the bench having come out of a prosecutorial role previously. How does that affect, in your opinion, the ability of a judge to dispense justice in a criminal setting, being that they spent their formative years, many cases, or the last several years as a prosecutor, and is that a necessary qualification to ascend to the Superior Court bench?
Let me address that. I think what happens is when you have, and this is for some prosecutors, I'm not saying all prosecutors, but when you have prosecutors who become judges, they sometimes forget that they're not a prosecutor anymore. And so what happens is when you're litigating a case, they have that bias that's already built in, and it's kind of hard for them to set aside that bias because they're already thinking that your client is guilty because they prosecuted clients like the client that you're representing. So when I'm trying a case, I mean, there have been times when I want to ask the judge, you want to come from the bench and sit next to the prosecutor because you're helping the prosecutor, you're trying the case for him. So you don't, as a litigator, and I know Steve can address it, but I call it working the battlefield every day, because a lot of our clients, they don't have the resources, they don't have, they can't afford an investigator, they can't afford someone to do research. And sometimes I have to be the investigator, the researcher, and the trial attorney. And so sometimes, when if I ask the judge, I said, well, Your Honor, even though my client has retained me, but he has not paid me all my money and he can't pay the rest of it, will you appoint an investigator to assist in his representation. And I can tell you, Steve, that I've had the hell no.
Yeah.
And so they don't understand that, okay, well, in terms of fairness, sometimes you have to say, okay, well, let me look into this. Let me see if I can go ahead and try to get some money for this person. So I think that as a prosecutor, and I do believe that we should have prosecutors as well on the bench, but we need some other defense attorneys who have practiced, and I think that they should also try to become judges. But I think that they need to understand, prosecutors just need to understand that, okay, you're not prosecuting anymore. You've got to be fair. You've got to be impartial to both sides, and resist helping your former colleague with trying their case.
You know, a lot of times there's different degrees. My question was always, well, what kind of prosecutor were they? And if they were good, decent prosecutors, that doesn't necessarily mean they'll be bad judges. Matter of fact, there's still a good likelihood that they will be a good judge. You know, you want to address issues. You wonder what they'll do, having come from the prosecution side, knowing that, you know, Officer A, B, or C was a ding-a-ling back then. He always had bad reports. Sometimes you even thought he was a liar. And now that you're up on the bench, you know, how are you going to feel about him testifying now? I mean, is it going to affect you? Are you going to be willing to not give him a pass? Just a quick story. I saw one time a judge hear a case. It was a motion to suppress. Old defendant, been cycled through the system many times. The only two people that testified at this motion to suppress were the cop and the defendant. And the cop said that it was consent, you know, walked up to him, started a conversation with him, and then got consent out of him. The defendant got up on the witness stand and denied it entirely. I didn't consent to any of this stuff. He came up and just, you know, told me to get out of the way. And at the end, without hearing any argument, the judge moved and said, I'm granting this motion to suppress because I've prosecuted this kid, this hard-headed SOB before, and he ain't ever agreed to a damn thing. And so I know that he didn't consent. And my old man leaned over and said, but does he realize the flip side of that is that he's a lying SOB? And what's going to happen from that? You know, are we gonna go to, you know, the police department, tell this guy's superiors, hey man, you might need to keep an eye on this boy. He gets a little jiggy with the truth. You know, it's you know, are you willing to do some things like that? You know, but you know, I'll tell you this much, and I'll brag about one of our judges. When we tried the Victor case, he offered himself up for recusal. If you think you got anything on me, we were about a month maybe out. He calls us all in, says, look, I'll give you 5 days to research it or whatever, but I'm offering myself up for recusal. And if y'all just agree to it, I'll get out of it. You don't have to prove it. And so we sat and scratched our heads and went on and on and on and on and on, and you know, the good, the bad. They're looking at me, wanting me to make the call, and I'm thinking as soon as I say, well, Al ain't a bad guy, you know, something bad's gonna happen and I'm gonna be the idiot that got us stuck. And I remember I said, this is what I'll say about him. I said, I've been in his courtroom 1,000,000 times. He's not always done what I want him to do. He's not always agreed with me, and sometimes I thought he was dumb and I wasn't. But I've never walked out of there and thought he effed me, or that MFer Al Collier. He has, you know, a temperament that while I thought, hey, look, we're not going to get a lot of these calls, you know, these special demurs and everything that we think we've got merit. He's probably not going to help us there, but he's not going to get in the way of us trying our case. He's not going to get in the way. He's going to get out of the way and give us a fair chance. And
Be
you know.
careful what you say on tape.
I understand. Well, I do. But, you know, he's an example of a prosecutor going to the bench that wasn't that bad.
Agents, you got any thoughts on that question?
I've had a couple of experiences with that here and down in Albany. The one thing that I have noticed from time to time is that, and this is in general, when you have someone who is a prosecutor who becomes a judge, in a lot of cases, because they have prosecuted cases, they know, or they have certain expectations for their prosecutors that are in their courtroom. And when they are not fulfilled, that causes problems. It has been, and I must admit, this has been to my advantage on at least one occasion I can think of, in which I've seen judges who have indicated, they've said, you know, look, I used to do what you've done, and I know you are capable of doing this. I know you have the ability to do this, or find this, or track this down, or things like that. And that particular experience, someone else who may not have prosecuted or may not have prosecuted from that office may not necessarily have that particular experience. So it can cut both ways. What I've usually found, the majority of our judges were former prosecutors. And just like Steve said, we've had very, very positive experiences with them, being fair to both sides and trying to give everybody a chance to do what we do best. And quite honestly, that's about the best we really ask for, is just to have the chance to get 12 jurors in there. And as long as we can get that, we're usually okay with the outcome.
So what about prosecutors, or the experience as a prosecutor being a qualification to be a judge? I mean, do you think it's fair that very rarely do you find people who have had a criminal defense background becoming a judge? Instead, the line of succession seems to be through the prosecutor's office to the judicial bench. Is that fair? Is that fair to people who make a living coming out of the PD's office or private practice as an attorney?
Yeah. I mean, I'll just say on this, quite honestly, in the public defender's office, anywhere I've practiced, none of us in the public defender's office anywhere in the state has any aspirations whatsoever of ever becoming a judge. We know this, and we're fine and okay with that. We do recognize that there's a certain, and this probably goes back 10 or 20 years when we had a lot of this talk within the legislative bodies about being tough on crime, and this perception a while back that these high crime rates were due to judges being all lenient. And so the perception was, we're going to get prosecutors to put them on the bench because they'll be tough on crime and tough on crime and tough on crime. And that's not quite what ends up happening. Being a prosecutor, sure, it's a qualification. Being a public defender or being a defense attorney is a qualification. Your experiences in life in general, and I know my colleague Francis talked about that earlier, your experiences make you, and they make you unique. And the diversity we're seeking on the bench encompasses people who have been prosecutors, people who have been defense attorneys, people who have been in elected positions, who have been mayors, who have run for, who have been legislators, people who have been, you know, who grew up poor, who grew up middle class, and things like that. Everything, there's very few things, or very few things I can think of that would be disqualifying factors. What I would like to see done is more, we talk about ethnic background, but just diversity in the backgrounds, in the life experiences of our judges. I would like to see more attention paid to that, whether it be as it relates to color or relates to region or anything else like that. That's what I would like to see, because each of our experiences makes us unique and makes us distinct, and I think it does help in some way to balance out some of the injustices that we've seen basically since this country's began.
I will agree with that, and I'll state that I have known public defenders who have sought office and defense attorneys who have strong public defender backgrounds. And this conversation about diversity absolutely addresses that as well. Because having judges who can be fair and impartial, who've been prosecutors, is wonderful. But having public defenders and defense attorneys on the bench makes for a richer bench. And we are all benefited by having that experience on the bench. I won't say that it's rigged, but prosecutors have a different kind of exposure to the powers that be, and as they rise through the ranks and actually start to seek appointments or election to a bench position, they're in a very different position from a public defender who has gone to a private firm, who is still doing criminal defense or a mix of civil work. It's not rigged, but the whole point of this conversation is that we want diversity and richness on our bench, and that should encompass criminal defense attorneys, absolutely.
If I could say something, the first panel talked about that there's a flaw in the appointment process. I've been around Clayton County politics for a long time, and as an adult since the early 1990s. And the reason why there's a lot of prosecutors on the bench is because that was, once a vacancy became available or became known to likely occur soon, the process, where they started looking first, those who looked around and thought, how are we going to preserve the status quo? The prosecution's office was largely the first place they looked. And as a community, that was validated. That was just fine. The community looked around and thought, hey, these are great people. Man, we can't get enough of it. And I think now, as I sit here, the epiphany I had is that as a community, the community needs to say, no, that's not going to be the passive system by which we find our new nominees. That there's going to be, that we're going to recognize the richness involved in diversity. And as a electorate and as a populace, we're going to, this is what, we're going to look other places. We're going to realize that, cutting them out of this same die all the time is not necessarily wrong. I don't think there's an attack that should be levied on it, but we're not going to change if that's all we continue to do.
Okay. That leads me into my next question. Sentencing. What are the factors in your practices that you think most heavily weigh on a judge's mind when your client has been convicted and now it's time for your client to get either 5 years or 20 years in prison or to get probation? What are the factors that most of your judges deem important when they decide this person gets 5 years or 20 years or probation?
Well, I think this man's on the line as much or more than anybody, so we'll let you open.
You're saying he loses more cases?
No, he's out there trying cases. I apologize.
Oh, okay.
I apologize.
The discretion, what I tell my clients is, in essence, there's a handful of factors. The first thing is, what are you charged with? It's one thing to have less than a gram of cocaine. It's another thing to be charged with a drive-by shooting that hits 4 people. It's a difference there, obviously.
Pull that mic closer.
Sure. So you look at how serious the offense is, and to some extent, the seriousness of the offense is, you kind of describe it as kind of the wow factor, the ick factor, depending on what the type of charge is. If it's something that's you read about and you're like, oh my God, like, that's a serious charge. You also look at the statute, because sometimes the statute will just tell you, look, they have to get this for this particular offense, or it's a mandatory minimum or something like that. There are certain charges that don't necessarily have mandatory minimums by law, but have a mandatory minimum because of who you're in front of, or because of the circuit you're in, or things like that. There are sentences that you can get in Fulton County that you will never get in any other county anywhere in the state of Georgia. I think we all know that. We've had clients tell us, well, I got this in Fulton County. Well, you're not in Fulton anymore. And so you look at that. First and foremost, what are you charged with? The second, and sometimes even greater thing is, how many times have you been here? How many times have I seen your face? How many times have you been here? What are your priors? Everything else like that. You've got no priors, you've got no history, your life is going to be a lot better and an easier place. If you've been here 7 times, the judge recognizes you by face, you have a problem. You just do. And then sometimes some of the other side factors, and to some extent this goes with, and I'll say it like this, class has an effect. When you have somebody, and the easiest one I can bring up is substance abuse. You have someone who has 5 or 6 prior convictions, theft offenses, they get arrested for a drug violation. They're probably looking at some kind of time, but you know, if the family has money, sometimes they'll call them and say, you know, look, we found a rehab place for him, or we found this, we found that. Do you think we can help us out? And a lot of times the answer is yes. And part of that is because the state of Georgia doesn't necessarily have traditionally they have not had the desire to treat substance abuse as a illness as opposed to a character flaw. Character flaws get arrested. Character flaws are in prison. Illnesses are treated. And so a lot of times when you have wealthier clients, they're able to work out something so that they don't go to prison, they can go to rehab. The same thing for mental health. Because I represent indigent clients, and pretty much everybody I get, if they can't afford to go to rehab, they're going to RSAT. RSAT is the state's version of that, and that's a decent enough program, but there's only 2 of them in the state. We have dozens of prisons. We have 2 rehab facilities for men. Do we have any mental health facilities? We have 1 now that treats that. So your ability to pay does affect it, and of course class does have a correlation back to race. So generally speaking, when I have a client who's an African American, they're poor, odds are, if they have a substance abuse issue, the options to them are not nearly as they're not nearly as open as someone who generally is white. They generally have a little bit more money. In a lot of cases, the family is aware of the system. They know how to interact with the system in order to achieve a better means of resolving it. And that's unfortunate, but that is the reality of it. Now, part of what I see in my cases is that, and your clients will do this too, they'll tell you because they're in the jail talking because they have nothing better to do. And they'll tell you, well, so-and-so got this, and so-and-so got that, and so on, and we get it all the time. And to some extent, we have to keep an eye out, and as in my courtroom or in anyone else that's assigned to a particular courtroom, we're always on the lookout to make sure that sentencing and things are fair. Because that is part of our job, is to make sure that if one person gets 5 years for something, the next guy doesn't get 20 for doing the same thing. And so, in terms of those aspects, those are the big 3. Those are really the big 3. When you have people that have, you know, other things such as family involvement, that's great. When you have somebody's mama, their father, things like that involved, that's a good thing. The few times that I have had a father come to court has sometimes made all the difference in the world. I had a situation once in Albany where a judge did a sentence, or he was going to sentence a guy, and the guy said, look, Judge, I've got kids. And the judge looked at him and he said, how old are your kids? He said he had 7 kids, and he rattled off each one of their ages and their date of birth. The judge let him go. And he let him go just because he said, you know what, you've presented to me, and his family was there, some sort of, you gave him a little bit of hope. So that's what I kind of see in terms of the things that most affect it. And it's not always fair, but, you know, that is the reality of the system.
Robert, yes.
One of the things I would like to add, I concur with counsel because I think this, you have to look at the seriousness of the crime, because a lot of times judges don't have really any other alternative but to sentence that person to, if it's a mandatory minimum of 10 years or so they don't really have that discretion. And also they will look at the background, the criminal history of the person to determine whether that person should receive probation as opposed to a fixed sentence of a term of years in prison. But also I would add politics. You'd be amazed at how many times judges will administer some type of sentence based on politics. Case in point, there was a case out in DeKalb County, and I won't name names, but there was a case out in DeKalb County where a lawyer was representing a young woman who was charged with murder for hire of her husband. And no one in the courtroom, including the judge, thought that the lady would be found guilty because the facts just didn't present itself that way. And so the lawyer during the trial, the criminal defense attorney, asked for a directed verdict. Well, the judge held off on it, making a ruling on the directed verdict, and said, we'll come back to that. He wanted a directed verdict of acquittal, basically saying that the state has not met its burden beyond a reasonable doubt, it shouldn't even go to a jury. Lo and behold, the defendant was found guilty. And at that point, the defense counsel said, Your Honor, what are you going to do about my motion for a directed verdict? Well, the judge at that point said, well, I'll hold off on that decision until a later date. But what I'm going to do is I'm not going to remand the defendant to the county jail. I'm going to allow the defendant to leave and go home, get a bond, whatever. And of course, you can imagine it started a ruckus in the district attorney's office. They filed all these motions, other things came out, and when it was time to come back to court to determine whether the judge was going to grant the motion for a directed verdict, which everyone felt like he should have, he denied it because there was so much political pressure. There was family of the victim that they were in an uproar. The media got involved, and I had a problem with that as not only as a trial attorney, but just as a citizen. Because my thing is, what's your belief? You took an oath, and you took an oath to be fair and impartial, and not be swayed by politics, not worry about whether you're going to be reelected. You took an oath. And if your gut and if the law said to you, I should grant this motion for a directed verdict, then you need to do that regardless of the political pressure. And so my thing is, when you are becoming a judge, I know you're concerned about whether you're going to get reelected in 4 years or so, but you have to understand that first of all, you have to take your oath very seriously. You did it as an attorney, as a private attorney, or as a prosecutor or whomever, and you have to administer justice based on the law, and that's it. And that's it. I had another situation. You didn't mention anything about bond, and this is probably another battlefield fight. But I was out in Douglas County the other day, and a client of mine was I was second attorney on his case. He's charged with vehicular homicide. Allegedly, he was drinking and driving, and he killed someone. Unfortunately, the person ran into him. And the first time he went to court, he had what is called a first appearance. He was denied bond. Doesn't have a criminal history, never been in trouble before, had a very good paying job, family. He was denied bond, and then his lawyer filed a motion for bond when he was indicted. And so went before this particular judge. The prosecutor got up and talked about how this was a horrible crime, and he had the victim family members there, and the judge denied the bond. Didn't give a reason why. He just sat there and denied the bond straight out. So when I got on the case, I filed a motion for reconsideration, and when it was time for the hearing, fortunately, the judge who denied the bond the first time was not on the bench. He was having surgery or something. So another judge came on the bench, and he was a senior judge. So he had been in that circuit before, but he had retired. Now he's just a senior judge stepping in for this particular judge. So we filed a motion for reconsideration. We had the hearing. The prosecutor called the entire victim's family up in front of the judge. So I turned around and asked my client's family to come up as well. And so the prosecutor gave his spiel and talked about the same thing he did before, why he shouldn't get a bond. And one of the things he said also, and Judge such and such denied him a bond, and Your Honor, he denied him a bond because of this and because of that. And so when it was time for me to get up, I said, Your Honor, you're not Judge such and such. I said, you have to make your decision on whether he's entitled to bond based on certain factors, not based on the victim's family members or how upset they are, not based on the politics of this, not based on what you think the community is going to do. You have to make that decision based on the law. And he gave my client a bond, which I thought was wonderful. The next day I had to go before the judge again on a counter call, and the judge that denied the bond the first time was back on the bench. I was like, whew, that was a close call. But the point is that sometimes politics get involved. And you have to make sure as judges that you don't let that affect you.
I want to say very briefly,
Go ahead.
just so that the room is very aware of this. Georgia is a very large state with 159 counties. Be very clear that sentencing is not fair across this state. And you said Douglas County? I've been there, and it's a scary county. Clayton is not a bad county.
Not anymore.
Not anymore, not anymore, not anymore. But the discrepancies in sentencing across Georgia are so concerning, I would add it to the list of things to address.
Okay. What I wanted to, you guys have done a good job of talking about sentencing and how different people are sentenced based upon their background and how many priors they've had, the severity of the crime that they've committed. But what I want to know is, does the background of the judge, that is the demographics, if you will, of that individual, his race, his sex, his age, his upbringing as an individual, does that have and play a role in what kind of sentence you can expect to get from that particular individual, in your opinion?
I'll address it briefly. Someone said in the earlier panel, I think it was the Reverend that talked about the fact that it doesn't matter the color of a person's skin, whether that person you should vote for that person. I'm a proponent of the fact that you shouldn't vote for a person simply because of their race. Because I think Judge Moore and I had a conversation one time before about there's some black judges that don't need to be on the bench. And Judge Moore was one of the best judges that I had ever gone before. Now, she may not have always ruled my way, but she would say it politely, denied. But she was fair. And anyone in this room who's ever been before her will tell you that she was fair. And they're just, you can't support a person just because they're black or just because they're female. You have to vet them. And so you have to determine, okay, well, if you were a judge and you had these set of facts and the person didn't have a criminal history and things like that, what would you do? Or are you so consumed with the thought that you want to eradicate crime and you so focused on crime, are you just going to sentence a person harshly just because that's how you feel? You need to vet these individuals. I mean, a lot of times when around this time of the year when people are running for office, they come out and they ask for your support and they shake hands, kiss babies, and slap backs. And they ask for donations. Well, I asked, okay, well, if I support you, then what are you going to do when you get on the bench? Are you going to be fair? And a lot of times, I'll be fair, but are you really going to be fair? So you need to vet these individuals and determine whether they're going to be competent enough, because as Steve said, the knowledge will come. These are lawyers, so they're intelligent enough to learn how to apply the law and review cases. But you have to vet these individuals and determine if they're going to be in your best interest. You're not asking, when I go to court, I'm not asking a judge to rule in my favor just because, we're friends or he may like me. I just want you to be fair. Just like with Judge Moore, if you're going to deny me nicely, just say, oh, I know, okay, well, she was fair. And that's all I'll say about that.
Go ahead, Steve.
Yeah, I think a judge's background, I wanted to say this a second ago, talking about Judge Moore. What I think as a community you should look at a judge and say is, because, she talked about judges being activists to some degree, is, do I want a judge that uses her power to take a chance to do what they think is right, or do I want a judge that's going to use their power to hide behind no? I'm smart, this is my position, and I'm smart enough to fortify it, you can't do anything about it. Talking briefly, I've been in Clayton County, I've seen, I arrived in 1971, so you ask me about judges and their background and upbringing and how does it affect their ability to administer justice to those before them. A judge, an unnamed judge, was having lunch with me one time, and they were discussing a jury's acquittal. And this particular judge was frustrated because largely, in order to acquit this person, you had to disregard the police state. You know, you had a cop say it. Cop said it. You know, cop got up and said, man, there it is, bam, bam, bam. How did this happen? And I looked at him and I said, well, because of course they're complaining about the jury. And I said, they've probably themselves, you know, I'm looking at you and I'm thinking, you've never had, nor do you know anybody that stood on the front porch and watched a police officer tell somebody's grandmama to shut the F up. And, you know, I don't have to all of a sudden think that, okay, well, that means every cop's a POS and no, we just need to listen. You ain't the only one on the playground. Your set of glasses ain't the only one we looking at. And, you know, this person was an intelligent person, but you could tell when I said that, it wasn't so much whether or not the cop actually said it. They couldn't really grasp that different perspective. You know, we used to have a comedian used to laugh about the police and about the different perspectives. You know him as Officer Tipton. You know, we know him as get out of the goddamn car. And I think you need a bench, you know, that at least will look at each other privately. You know, I'm not asking them to take a public stance on this, but at least have the courage to say amongst yourselves that, hey, this is an issue.
I agree. What I'll add to that is that you're addressing the issue of prosecutors ascending to the bench. I think that you have to be the type of person that understands that just because the person is a police officer and you were a former prosecutor, you may have dealt with that police officer or dealt with other police officers, that they're not always right or truthful. We know that, especially in our community. And I think also, you know, I'm not here to bash prosecutors. I'm not here to bash prosecutors who are trying to become judges. I've worked with several prosecutors in this room who are very, very good, very compassionate. Ms. Chandra's over there, Marcus, as well as Steve was a prosecutor one time before. We had a case down in one of the sticks, and he was fair. I mean, we've got some good prosecutors in this room who were very, very fair. I think, Chandra, we had a case together where my client had some mental issues, and you know, he had been charged with decent exposure. I can't remember the facts, but you know, she and I worked it out. We recognized he was he had come from Afghanistan and one of those places, and he was under the care of the VA. And there have been some prosecutors, when I've had cases like that, they don't care. But Chandra said, well, let's hold off, let's get him some help, and let's see what we can do to work this out. And eventually, she, I think, did the right thing, and she dismissed the case. Marcus and I had a case as well. My client was beaten by the police. It was, in my opinion, a police brutality case. And we ended up working that case out as well. So there are prosecutors, and I think we do need black prosecutors, as well as black prosecutors who are ascending to the bench, because they can recognize some foolishness and work things out when they're supposed to.
All right, you remember my email? I said, don't call any names. It's judges and prosecutors in the room.
We're speaking the
We'll
truth,
see
right?
them again. Okay, now, I got one last question. When you guys go before a judge that you've never been before previously, what kind of intel do you do on that judge, and how? And what is the reliability of the sources that you may use to do intel on that particular judge?
Yeah, I'll start this out. Only because I've traveled, I feel like the circuit. I've had cases, and I can't count 159, but I'm sure it's very high. And the other Georgia that someone mentioned earlier is very real. I think we all know Metro Atlanta area is an island unto itself. And outside of Atlanta Metro, it's a very different state. So what I do when I have to go to the Florida border with a case is I reach out to my network of bar associations and colleagues and those trial attorneys, not the transactional attorneys, but the actual trial attorneys who appear before judges all over. I'll ask them, has anyone tried a case in front of Judge Smith? Just the random name, Judge John Doe. Please contact me. And I do everything I can to have a conversation, even if it's 5 minutes, to get a sense of not just their background, because it doesn't matter to me if they were in a previous life a prosecutor, but their temperament now. And my first question is, will they let me try my case? Is it a judge who will let the attorneys present their strategy, their theme in their defense, their offense, the whole deal, without shutting it down or trying to rush a case to a verdict because they have an appointment or a trip or some other conflict that starts on Wednesday? And that's very real, people. That's very real. Yes. And I'd like to know if they respect conflicts of interest, like, calendar conflicts, because trial attorneys, any given Monday, we're on 2 or 3 different calendars. And I need a judge, I hope to have a judge who respects those conflicts and will not have me be in 2 places at one time. So these are the critical questions that I ask. And finally, are they defense or plaintiff oriented? Now, I practice civil now, but I've done criminal work. And I need to know if they favor the prosecution or if they favor the plaintiffs. And there's a way I try a case depending on the answer to those questions, all of those.
Okay, ages.
Since in the public defender's office, most of them, you're assigned to one particular judge. So I kind of get the opposite, which is I can usually tell anytime I see an attorney in the courtroom who's never been there before, they kind of walk in, they're usually wandering around. They're looking around, trying to find who the prosecutor is, who the paperwork is. Sometimes because of the way the chairs are oriented, they'll come to me thinking I'm the prosecutor for some reason. But what'll end up happening, I've had a number of private attorneys who will come to me and they'll say, well, tell me about this judge. And I've had we've had these conversations at public defender meetings. We say, look, if you see a defense attorney who just looks like they need to know what's going on, reach out and help them out. Tell them what's going on. If you've got a suggestion, by all means do it. Even if it's something as simple as, where's the form that you sign if your client wants to plead guilty? Do you mind if, simple stuff such as, do you mind if I go in front of you? Private attorneys, generally speaking, in front of my judge, they go first. If Steve comes into my courtroom, he's going first. I'm not going anywhere all day. Steve probably has some place to go. That's why he has the nice car and I don't. So, so it's those kind of things, and because I have an interest in not only seeing my colleagues on the defense bar doing well, but I have kind of a compassion for people who have been arrested, who've been charged with something. I want to try and help you out here. I want to at least give you a little bit of information. Hey, this particular judge is going to do this. This particular judge is going to do that. That prosecutor, talk to her about this, discuss that option, things like that. When I was in Albany, I had a judge who did the drug and mental health court. He started it, he ran it, he was very, very passionate about it, very, very passionate. And when we would get private attorneys who would come in and, he might say, yeah, I've got a client, he did this, yeah, a few years back he was diagnosed bipolar, and I'd say, hold up, wait a second. Find out, go do an evaluation on him, bring that information back. This judge is gonna want to hear that, absolutely. And it matters, and sometimes that can be the difference between 10 years and 5 years, or 2 years of probation, or anything else like that. So if I see you, I would be there to help you, just like anybody else if you ever have a question. So that at least was a role that we all take up in our office very, very seriously, because it affects the administration of justice. We don't want to see an imbalance or an injustice anywhere. We don't want to see our guy get one thing and someone else get another, and then we walk out of the court saying, your person got messed over. We don't want to see that under any circumstances.
Okay, anybody else? Let me ask this question. Nobody mentioned this yet. Do you guys look at, particularly civil lawyers, do you look at whom has contributed to a judge's campaign?
No.
Or does that make a difference?
No, the judge, we know that judges can be influenced, but for me, I've never gone that far. A judge who's been on the bench for any time has a record and a reputation in our community. And that's where I go. That's what matters for me.
I have never, and I do civil litigation as well, but I've never actually looked into whether my opposing counsel has contributed to a judge's campaign. Sometimes after the ruling, I assume that person has. but I've never actually done so. I've had situations where, and this may be a side issue, but I've had situations on the civil side is when you have a judge who has come from a defense-oriented background, meaning they work for a large firm, they've done insurance work, they tend to deny motions, or not deny motions, grant motions for summary judgments, things of that nature, because they already have an eye towards, okay, I used to be a defense insurance person, and they want to grant everything for the post side. So I've never had a situation where I've just actively looked into their background. Maybe I should, though.
You should.
Going forward.
Okay, at this point, we're gonna open the floor up for about 5 to 10 minutes of questions, and then we are going to adjourn this forum. We do have some lawyers who have agreed to provide some free legal consultations to anyone that might be interested in that. So we will allow them to do that as well. So we'll start with any questions anyone has of this particular panel. Yes, ma'am, in the back. Yes.
Good evening. The question that I have is that in the cases that you all are going through, and you're going through your paperwork, and you're going through the details of your case, how important or how much of the case truly relies on, basically speaking, mainly of criminal offenses? How much detail has to be correct when it's the officer's report, and you go through that report? If it's a crime that's being committed, how much of his report has to be accurate? Can he be wrong about the offenses he's charging a person with, about the things, the details, the color, the weight, the height? Can those things still be wrong and someone still be held accountable for their crime?
I think that question goes to lawyering skills. I've had cases where I've looked at the police report. Let's say it's an issue of identification, and the issue in the case is whether my client is the one that actually did the crime, based on the identification. So what I may ask the officer or something, is involving an officer, okay, what color shirt did the person have on? What color, color eyes? What color pants? Did the person have on gloves? And based on the police report, if the police report says something totally different, then of course you use that for cross-examination to try to show that this officer or this witness is not credible. So I think that goes more to lawyering skills. In terms of, even with jurors, I've had cases where it was an identification issue. I had one case where it was a cab driver. My client was charged. He and another person charged with robbing a cab driver in Clayton County. And it was one of identification. And we know that sometimes people think, all black folks look alike. And that's true. I'm not just saying it because that's what they say, but I see that all the time, especially with white jurors. And so one of the things I do is I've done, and I think that it has worked. I don't know who I stole this from, but I'm pretty sure I didn't make it up. But what I have done is I had one case, and I asked the jurors, I said, I tell you what, I want to ask you guys to close your eyes. And this was during closing argument. And it was in Clayton County, and all the jurors closed their eyes except for one little black lady. She was like, I ain't closing my eyes for nothing. I want to see what's going on. She didn't close her eyes, but the other jurors closed their eyes. And I said, okay, you've been with these jurors all week. You've gotten to know them. You learn a lot about their backgrounds. You've been with them all day. I want you to think about the person to your right and describe what that person has on. Does that person have on a white shirt? What color shirt? What color shoes? Does it have on earrings? Does it have a tattoo? Anything. So then I said, well, to the person to your left, the same thing. And I said, so if you can determine what this person had on to your right and to your left, or you can't rather, then how can you be certain that the witness who claimed they saw this person at night and it was not well lit, and it was a gun in front of their face, can describe the person? And I said, okay, now open your eyes. And a lot of them, they wanted to look to their right and look to the left, but they didn't. But my client was found not guilty because, and now when I spoke with the jurors afterwards, they felt that that was pretty effective. So I think a lot of it has to do with just loyalty.
Okay. Any other questions?